In recent years, there has been a dramatic increase in the number of people who meet a new boyfriend or girlfriend, for lack of a better term, after they've been divorced, after they lost their spouse, and the two of them decide to live together, but not be married. That is an increasingly common phenomenon. I will tell you from my own experience in working as an elder law attorney that this is an area that is ripe for conflict if you don't plan appropriately. I'm Patrick Coley with Keystone Elder Law in Mechanicsburg, Pennsylvania, and just from the client experiences I've had, I want to share a few things for you to think about, and even better, a few things to write down. Now, I'm not trying to over-lawyer your relationship with your new partner, but I see what happens not only with the partners themselves, but with their children. Their adult children get very worried. They start to resent the new boyfriend or girlfriend only because they think that there's financial manipulation going on. They think somebody's trying to take advantage of the situation. So here's just a few things to think about. The details are beyond the scope of a short video, but I'd be happy to meet with you and talk you through some of these issues if this is the circumstance that you're in. But number one, so what are the living expenses? Who's handling the living expenses? How will they be divided if one of the people in the couple is giving up their home, moving in with the other one? Is the original homeowner going to receive rental payments from their new partner? That should really be written down for a number of reasons. Number one, it has to be clear that when the original homeowner passes away, is there any equity interest in the home? House gets sold, does the person who's been paying once a month for living expenses get anything out of that house? If so, that would definitely have to be written down. Something else that should go into your will or your trust or both. If the original homeowner passes away and the intention was to leave it to his or her children, what about the partner who's still living there? Do they get to live there? Do they have to move out? How long do they have to move out? This should all be spelled out in your legal planning, or at the very least, some sort of written agreement that the two of you come to. But even better if it's built right into your will or your trust. Finally, what happens if one of you gets sick? Because the statistics do not look good especially once you get to 65 or beyond. The rates of dementia go way up. The rates of having a stroke, having MS, ALS, Parkinson's, dementia, it's all very high. So if you need a higher level of care, are the resources there to pay for that? Are you going to help each other financially? That has to be in writing for a number of reasons. Medicaid, unfortunately, Medicaid's great for paying for long-term care in certain circumstances. It might save you $13,000 a month, but it treats married couples better than it treats single individuals or unmarried couples, whereas a married couple can simply transfer assets into the name of the person not needing care, that spouse, and there's no penalty. That's what you're allowed to do. You can't do that if you're not married, because if you start moving money around, giving money and not getting anything in return, Medicaid penalizes you and makes you pay privately for care for a certain number of days that they compute based on the size of the gift, and then Medicaid kicks in. So that's a very costly mistake to make, to be giving money. But if you have a written agreement where it's really all coming down to sharing expenses, maybe a caregiver agreement if that is where things are headed health-wise, that documentation goes a long way to avoiding penalty periods with Medicaid. So this is, later in life, this is just part of the reality of your legal planning and something to think about. Like I said, the details are all beyond a short video, but I'd be happy to talk to you more about this if you have questions, if this is the set of circumstances you are in. But I encourage you to have conversations with the children, put things in writing. It will go a long way to avoiding conflict and stress in the family. I'm Patrick Coley. You can find me at KeystoneElderLaw.com. Feel free to reach out to my firm and we can talk about this further.